In reading the judgment, I shall simply read the claims and then I go straight to the decision section.
As the court pleases.
All your submissions, everything is included in the judgment.
As the court pleases.
As the court pleases.
The claimant filed this complaint against the defendant on the 21st of September 2015, together with the accompanying originating process, by an amended complaint and statement of facts filed on the 2nd of December 2015. The claimant is seeking the following reliefs. A declaration that the purported resignation of the claimant with effect from 28 May 2015 by a letter dated 11th June 2015, while the claimant was still on medical treatment on an injury she sustained in the course of her employment, is illegal, unjust, and amounts to unfair labor practice. B, a declaration that the issuance of letter of termination, services no longer required to the claimant by the defendant during the pendency of this suit is wrongful, illegal, null, and void. C, an order of the Honorable Court directing the defendant to refund to the claimant of $25,000 she incurred in the operation in the injury she sustained in the course of her employment with the defendant. I hope you can hear me.
Yes, my lord. Very well.
D, an order of the Honorable Court directing the defendant to pay the claimant her arrears of salaries and allowances from the date of the purported termination of appointment letter until the final determination of this suit. E, an order directing the defendant to pay the claimant the sum of 20 million naira as punitive damages for the unfair labor practice meted to her and permanent injuries sustained while in the course of her employment with the defendant. F, cost of the action. The defendant filed a statement of defense together with the accompanying processes on the 21st of April 2016. The claimant filed a reply on 17th of June 2016. I will go straight to the decision section now.
Court pleases.
As the court pleases.
I have carefully considered the processes filed, the evidence read, written submissions, arguments, and authorities cited. It is the law that when an employee complains that the terms of his or her employment contract have been breached, the employee has the burden not only to place before the court the terms and conditions of the employment, but the manner in which it was breached by the employer. C.O. Kobo versus Police Council, Idoni Boye Obu versus NNPC. In furtherance of this, the claimant has placed before the court her letter of employment, Exhibit C1, contract of service, Exhibit TO1, year 2015 annual leave approval, Exhibit C3, letter of termination, Exhibit C9, letter of indebtedness, Exhibit C7. The issues that arise for determination, therefore, are as follows. 1, whether the defendant authorized the claimant's absence from her duty post after the 18th of May 2015. 2, whether the termination of the claimant's employment was wrongful. 3, whether the claimant is entitled to a refund of the medical expenses she incurred in the United States of America. 4, whether on the pleadings and evidence, the claimant has established unfair labor practice. It is not in dispute that the claimant suffered a fracture on her ankle while on official assignment, and she was immediately taken to St. Martin Hospital, Port Harcourt, one of the defendant's retained hospitals, where she was admitted and treated. Her leg was placed in a plaster cast, POP, and the doctor told her that the cast would be on her leg for 12 weeks. The claimant was discharged after 3 days and given 2 weeks leave. At the expiration of the 2 weeks leave, the claimant resumed duty with the cast on her leg. It was removed 12 weeks later. I believe the claimant's evidence that after the cast was removed, she continued to feel pain and discomfort when walking. The claimant admitted that the defendant was responsible for her medical expenses at St. Martin Hospital, Port Harcourt. It is the law that facts admitted need not be proved. See Unity Bank PLC versus Denclaff. The claimant's evidence is that she applied for 2 weeks annual leave thereafter, and she traveled to the USA in a bid to find a lasting solution to her pains. The defendant granted her approval to proceed on 10 days annual leave with effect from May 4, 2015, and to resume duties on May 18, 2015. In cross-examination, the claimant admitted that her trip to the USA was not on account of medical leave, and that she did not resume duty on the 18th of May, 2015. The claimant confirmed that she signed a contract of service, Exhibits T01 and D2, and agreed to the provisions in the contract. The relevant provision in the service contract is clause 12, and it is reproduced as follows. Illness. If you are unable at any time to attend at the bank in consequence of illness or other unexpected cause, you shall make known the cause of your absence as early as possible on the same day in writing, practicable, to your branch manager or head of department. In the event of any absence through illness extending to 3 days, you shall furnish a certificate from a qualified doctor, and if required by the bank at any time, submit to any examination by any other doctor approved by the bank. Medical attention shall be provided at the expense of the bank within the terms of the company's medical scheme and or the National Health Insurance Scheme. Excuse me, please. In the event of occurrence of an emergency, such as accidents or sudden illness, to the extent that your life or that of any member of your family approved by the bank is in serious danger, and where treatment takes place in any hospital outside the hospitals within the scheme, the bank shall reimburse you for the expenses incurred. End of clause 12. The law is settled that parties are bound by the express terms and conditions of a contract of employment in writing freely entered into. See Gateway Bank of Nigeria versus Abosede. See Isheno versus Julius Berger. It is also the law that once a party asserts, he must prove the assertion. Section 131, 1 and 2 of the Evidence Act. The claimant failed to produce a copy of the email she claimed she sent to the defendant applying for 4 months leave based on the program drawn up by the surgeon. In paragraph 31 of her deposition, she admitted, and I quote, "The defendant neither approved nor disapproved of my extended stay." I find that the claimant, in applying for 2 weeks annual leave, concealed from the defendant her intention of going to the United States to find a medical solution to her health issue. It is my considered view that the claimant ought to have known that a medical solution to her health issue would require more than the 2 weeks annual leave she applied for. And for this reason, she ought to have disclosed her real intention to the defendant and then proceed to make the proper application for a medical leave. She failed to do this. The defendant did not extend her annual leave beyond 18th May 2015. I find that the claimant's absence from duty from the 18th of May 2015 was unauthorized and in breach of her employment obligations to the defendant. The claimant has admitted that she did not get a referral from St. Martin's Hospital for further treatment or for a second opinion. She confirmed that the hospital where she had the surgery in the United States is not within the terms of the defendant's medical scheme. Neither is the facility where she was managed in the USA within the defendant's medical scheme. From the totality of the evidence, the claimant's health issue was not an emergency, such as accident or sudden illness that put her life in sudden danger, as stipulated in clause 12 of the service contract. Therefore, the claimant is not entitled to reimbursement for her medical expenses in the USA, and I so hold. The claim for a refund of $25,000 fails. The claimant has complained that the termination of her employment was wrongful and that it was done during the pendency of this suit. The claimant in paragraph 19 and 20 of her pleadings averred as follows. 19, that on the 28th of May 2015, the claimant received an email from the defendant directing her to meet with the head of HR. Few hours later, she noticed that she could no longer access the email platform of the defendant. On the same day, she also received an alert of 191,072 naira, 91 kobo, with alert description, 1 month due. Paragraph 20. The claimant received another email on her personal email account on the 11th of June 2015, captioned Letter of Indebtedness. And in the letter, the defendants made reference to the claimant's purported resignation and instructed her to offset her indebtedness to the bank. The law is settled that parties are bound by their pleadings. See Woluchem versus Gucci. It is clear from the claimant's pleadings and the evidence of DW that the claimant's employment was terminated on 28 May 2015, and she was paid 1 month's salary in lieu of notice on that day, as seen in Exhibit C9. The claimant was absent from duty without permission for 10 days before the defendant terminated her employment. The claimant's employment was not terminated during the pendency of this suit. She filed complaints on the 21st of September 2015 after her employment was terminated. The payment by the defendant of 1 month's salary in lieu of notice is evidence that the claimant's employment was terminated. And so the word resignation used in the letter of indebtedness is simply erroneous and it is irrelevant. I hold that the termination of the claimant's employment was in accordance with the contract of service. The declaratory reliefs sought in claims A, B, and D are refused. The claimant has asked for punitive damages in the sum of 20 million for unfair labor practice. The claimant has not established unfair labor practice or permanent injuries that she sustained that entitles her to an award of punitive damages. On the whole, the claimant has failed to prove her case. It is hereby dismissed. Costs in the sum of 100,000 naira awarded the defendant. Judgment is entered accordingly.
As a call, please.
Mrs. My Lord, we are very grateful for the well-considered judgment. And I thank my Lord for the industry in the judgment. I will continue to be educated whenever I'm before my Lordship. I thank my Lord.
Thank you, Mr. Uye.
We also thank my Lord for the judgments. We're grateful.
Thank you. The judgments, the signed judgments will be sent to the Lagos division. Pending when the signed judgments get there, the registrar of Court 3, Lagos will send you the judgments in soft copy within the next 7 days. That is if the signed judgments have not got to Lagos.
Thank you, my Lord.
Madam,
Thank you, my Lord.
Thank you.